Okay, good evening, everybody. It's 7 o'clock now. We might as well get started. Welcome to part 2 of our officer-involved shooting series. It's going to be a 3-part series altogether, so keep an eye out for part 3, probably sometime early spring. Again, my name is Ronald Pugliese. I go by Jay. I'm an attorney with the law office of Eric R. Brown and Nutmeg Independent Labor Unions, for those of you that don't know me. If there's anybody out there that is not one of our member unions and you would like some more information, my contact information is here. And we also have a slide at the end of the show here for you to just reach out to me anytime and we'll send you all the information that you need. All right, so like we talked about before in the first part, if you missed it, being involved in a shooting or a serious use of force incident can be one of the most stressful things that you're ever going to go through as a police officer. And we use the term a lot, officer involved shooting here, but we're also those lines, not that we use chokeholds anymore, but you could some other type of force could lead to the death of a suspect. And that would also be covered here. A lot of the same principles still apply. And also an in custody death. So if you're transporting a prisoner who either dies in your police car or back at the station in the cell, again, those are all kind of encompassed in the same topic, and a lot of these same theories as we go through the series here will apply the same. All right, so tonight we're going to talk a little bit about why you need a lawyer when you get involved in an incident like this, and why it shouldn't just be any lawyer that you pick out of the phone book. Your lawyer needs to be specialized and understand the types of incidents that are happening and the legal ramifications of the 2 different types of investigations that are going to be happening here. And those are the administrative investigation and the criminal investigation. And we're going to get into the differences, what those are. We're also going to talk a little bit about how to write your report and your IA memo, if that's what your department requires, and how to prepare for your interview. And I put them in this order specifically so that you're going to work with your attorney to write your report and your memos first. And that is how you're going to essentially prepare for your interview. And if possible, we'd like to be able to bring a statement pre-written hand it to the investigator and just have them ask a few follow-up questions and go on from there. But after all that is said and done, you as the officer have to deal with the stress and the mental pressure of possibly having taken someone's life. And that can be really difficult on people. So tonight we're going to talk a little bit about the mental health process and what happens after the incident and how it affects you, it affects your body, it affects your family, it affects your home life, it affects your work life. And as we talked about in the first series, in the first webinar in the series, when you get involved in an incident like this, it's standard procedure to be put out on administrative leave. So you're taken off the road. You're either put out of work altogether or put on the desk or something like that. And we're going to talk a little bit about what it means to be fit for duty and how to get back to work safely and make sure that you're ready to get back to work. So those are the topics that we're going to be covering tonight. And when we do part 3, we're probably going to focus heavily on the mental health aspect of this and focus a little bit more on EAP and some of the different treatment options out there. Well, we'll touch on them tonight. Part 3 is going to be really focused almost specifically on the mental health aspect. Okay, so when you get involved in something like this, you want to have the right lawyer. You don't want to have the lawyer that does that closed on your house. You don't want to have the lawyer that wrote your will for you, or even the lawyer that helped you after you got into a car accident or something like that. These these incidents are very, very specialized. There's a lot of legal, there's a lot of statute that goes into these. There's a lot of case law that goes into it, and there's also a lot of knowing police procedures and best practices. And the right lawyer is going to be versed in all of those areas. And depending on which part of the investigation you're in, whether it's an administrative investigation or a criminal investigation or both, you're going to want to have a lawyer that's versed in that type of law as well. So some of the things that you're going to be looking for is you want to make sure that your lawyer is versed in the actual type of law that you're looking for, whether it is administrative, such as like your union lawyer, or whether it's a criminal defense attorney. And now where we don't do criminal defense, and I'm not specialized in criminal defense law, so I should not be the one representing you in court if it ever goes that far. But I can help you on the administrative side. And what we also can do here at Nutmeg, though, is if it does go to where you think you're going to need a criminal lawyer, we can certainly refer you to somebody who we trust and we have vetted and we know is going to take care of you and do what's best for you. You also want to make sure that your lawyers are experienced in defending police officers. You want to make sure that they've gotten either had some training in it or have handled these types of cases in the past, and that they can be understanding of what you're going through as a police officer and not judge you simply for being a police officer. And we know how that can happen in today's day and age. And some of the lawyers out there would rather make you look bad than put the criminal in jail. So we want to make sure that we find the right one. And like I said before, we've got a few lawyers that we work with, a few criminal defense lawyers that we vetted, and we know are good at what they do, and would be comfortable referring you to them if that's what it came down to. The other big issue that goes into legal counsel, as with any professional, they're expensive. For the most part, the administrative aspect of it is going to be covered by your union. But if you're in a jurisdiction that's non-unionized or doesn't have a union, then it might be an expense that you have to pick up. There are some legal options out there to help you with those costs, such as legal defense funds. We personally recommend PORAC, and it's got a small monthly fee, and that gets you legal representation. It pays for your lawyer for any administrative investigations or criminal investigations that come up as a course through the course of your job. So if you're off duty and you get into a little bit of trouble and get into a fight, or you get a DWI or something, the legal defense funds are not going to cover the criminal aspect of that, but they may cover the administrative side when an IA is opened. So keep those in mind. There's a few of them out there. And if you'd like some information on those, send me an email. I'll be more than happy to send you all the information that we have and help you with some recommendations. All right. Okay, there we go. The computer's acting a little funny here. Sometimes it's jumping 2 slides. Okay, so the first investigation that we're going to talk about is the administrative investigation. And when I say administrative investigation, I mean the IA, the internal affairs, the investigation that's going to be done by your own department or another department or agency with the specific intent of making sure that your use of force falls within policy. This is not the criminal investigation. This is not to be done by the state police or another criminal investigations department or agency for the purpose of finding out whether it met the law. This is strictly about your policies and procedures and whether your use of force or whatever the incident was, whether it be an in custody death, falls within the parameters of your policies. The other part of the administrative investigation, and different jurisdictions differ on this, could be your certification. So here in Connecticut, the police officers are certified by the Post Council, the Police Officer Standards and Training Council. And there is a process where they can decertify an officer for certain reasons, and one of those reasons is excessive use of force. So if the IA leads into something more substantial, like an administrative investigation in front of by the Post Council and a hearing over your certification, then we would cover that as well. And your administrative lawyer should be versed in those aspects as well, and the post regulations and the procedure for due process there, and asking for a hearing and all that. So it's important that your administrative lawyer not only knows your policies and procedures, but also knows the certification standards and how that might play in with a possible decertification, if that's what it comes to. There's a few rights that you have as both a union member, if your department is unionized, or simply as a public sector employee. And when I say a public sector employee, I mean you work for the government. So because you work for the government, whether it's local, state, or federal, you have some a property right and a liberty right in your employment. And the government can't take away your property or your liberty without due process. So we're going to get into that a little bit, but what I'm going to start with here is your Weingarten rights. And this is by virtue of being a union member. And if you're not a union member, this is a pretty important one. You should probably think about it and give us a call, and we can help talk you through that. So like with a lot of these rights, Weingarten was named for a Supreme Court case. And again, like I said, it only applies to unionized employees, but it also applies to private sector unionized employees as well as public sector. And all this really does is give you the right to a union representative or your union attorney to be present during any investigations that might lead to discipline or at a Loudermill hearing. And we're going to get to what a Loudermill hearing is in just a minute. But it's something that if you're going to be called in for an investigative interview, whether it be on an officer involved shooting incident, or whether it's because you came in late to work and now they're thinking about disciplining you because of it, you should always exercise your Weingarten rights and always ask for a union representative. And that representative could be somebody from your local union, like the union president or the union steward, or it could be somebody from your parent union, like here at Nutmeg, it might be myself or Attorney Brown. If you're with AFSCME or some of the other larger unions, you're probably going to get a rep, not a lawyer. You'll get a rep. So, but they can come and they're trained, and they can try to assist you through these investigations as much as they can. One thing that you do not have the right to is to have a third party come in. You can't just pick anybody from your union. You can't just pick, your partner if they're not part of the union e-board or recognized as a union representative by the department. And you can't have a family member or a friend, even if it's a lawyer, come in. You can't ask for a private lawyer to come in on these. The employer does not have to grant those. They can, but they don't have to. So stick with your union, talk with your union lawyer, and schedule any interviews and Loudermill hearings or any other investigatory meetings around the lawyer and the employer's schedule, so that everybody can be on the same page. Okay, the next right that I want to talk about is your Garrity rights. And I'm sure you've heard of these before. This again comes from a Supreme Court case, but it's derived from your Fifth Amendment right against self-incrimination. And I'm sure most people on here are police officers, so you all know what Miranda evidence. And Miranda, basically, like we all know, you have to warn your suspect if they're in custody and you're going to be trying to solicit information, custody and interrogation. You have to warn them and tell them that they have a legal right to remain silent. When you're in an employment context, you don't necessarily have that same right. The employer can order you to speak, answer questions, and tell the truth. But if they compel you to talk and compel you essentially to incriminate yourself, you still do have a Fifth Amendment right against self-incrimination. So the Garrity Rights advise you of all this. And we're going to talk about exactly what the rights are in a minute. But if you're read your Garrity, what it essentially means is that you're being compelled to talk to the investigators, you're being compelled to answer their questions, and you're being compelled to tell the truth. However, that information cannot be used on the criminal part of the investigation. And we're going to talk in a minute about why it's important to keep those investigations separate. This is one of the biggest reasons why. You do not want to mix these two investigations and allow the criminal investigators to hear what you've said in your administrative interview. And if there's one takeaway that you come away with tonight, it's that do not ever mix the investigations. Okay, this slide here just shows what the Garrity Rights are. This is just your basic Garrity Rights, kind of a model form, if you will. And if you're sat down at an interview, the representative from the employer, whether it's the chief, whether it's a lieutenant or a captain doing the IA, or an outside law firm that's been hired or something like that, they're going to have a form similar to the Miranda warnings form that you fill out. It's going to have your name and information on it and something that relates it back to the actual investigation. They're going to read you these rights. They're going to allow you to read them. They're going to make sure that you understand them, probably have you initial and have you sign. And whenever I'm involved in any of these, I also like to make sure that I read them as well. Granted, they're all pretty standard, but you want to make sure that nothing else was slipped in there that you're signing your name to. So let your lawyer, let your union rep review them as well and make sure that they are what the only information that's on that form is what's supposed to be on that form. Okay. So the next right is going to be, again, very specific to public sector employment, not necessarily unionized, whether you're a unionized worker or not. Every public sector employee has the right to a louder hearing. And again, this comes back to due process. The government cannot take your life, liberty, or property away from you without due process of law. So in the employment context, due process of law is generally believed to mean that the employer has to explain the case to you, explain the evidence that they have against you, and give you the opportunity to respond to that, give you the opportunity to provide evidence to dispute the employer's claim, and give you an opportunity to explain yourself and talk a little bit about why you think the employer's determinations are incorrect or not complete or something like that. It gives you the opportunity to tell your side of the story. And it also, sometimes these are very informal, sometimes they're very formal. I've seen some where it's just a meeting in a conference room where you have an opportunity to talk through the case. Others may happen in a little bit more of a quasi-judicial setting where the mayor or the chairman of the commission or even the chief of police may preside over this thing like a judge and allow witnesses to be heard and testimony to be presented and evidence to be presented. So they kind of run the gamut. But talk to your lawyer, talk to your union representatives, and make sure that you do have an opportunity to tell your side. You do get that due process that you're entitled to as a constitutional right. So now, I think we covered the administrative investigation pretty well. There's a lot of rights that you have, but you have to exercise them. You know, you have to make sure that your administrative lawyer, your union lawyer, is up to date and knows these, and they all should be. And make sure that you're protecting your rights, that your lawyer is actually making sure that Garrity is read, making sure that you have a Loudermill hearing, and making sure that you have proper union representation. Now, on the other side is the criminal investigation. And the criminal investigation, as we all know, is really no different than any other criminal investigation. The only difference is you're the suspect. And I hate framing it that way, because as an officer, if you're involved in a shooting, you are not a suspect, and you never should be referred to as a suspect. You're a survivor, and essentially you're just as much of a victim as anybody else. You now have to live with this for the rest of your life, and you certainly are not going out there intentionally trying to harm somebody. So I don't ever like to call them an officer a suspect, but unfortunately, other people may have a different opinion. And there may be some prosecutors out there, whether they're looking to make a name for themselves or bowing to political pressure, that are going to go out and try to bring charges against you. So we want to make sure that we understand the criminal side of it as well, and that you have the proper representation there. And the criminal investigation, like I said, it's going to be just like any other homicide investigation or other use of force investigations. And it's going to usually be done by a different agency than the agency you work for. So here in Connecticut, it would generally be done by the state police. They'd come in and they'd process the crime scene, and they'd collect all the evidence, and they would start the criminal investigation out of it. They would start doing interviews and, you know, canvassing the area and looking for witnesses and that kind of stuff. In other jurisdictions, it may be different. Some of the district and state's attorneys may have specialized units that handle police-involved shootings and serious use of force cases. Connecticut has just started a new office within the Division of Criminal Justice called the Inspector General's Office, and they're tasked with not so much investigating, like you're not going to see them out there processing the crime scene. The state police are still going to do that, but they're going to have inspectors, and they're going to have prosecutors assigned to this office that are going to be reviewing all of this data and finding and to see whether the use of force was lawful. Not so much whether it was in policy or not. That's the purpose of the administrative investigation, but whether it was lawful, whether you're allowed to do it under the law, or whether it's illegal. If it gets a little higher than the state level, you may see the Department of Justice come in, and the FBI, and they'll conduct a federal criminal investigation and process the situation that way. Again, I cannot stress this enough. You have to keep these two investigations separate. Don't let them mix. Don't try to save time by putting everybody in one room and doing one big interview, because you do have different rights. And your administrative rights and your criminal rights often conflict. So, and as an example, if they sit you down as a criminal defendant and ask you questions about this, you have the right to remain silent. And in the administrative side, you may not have that right, but you still have some protections against self-incrimination, because what they've compelled you to say under Garrity cannot be used in the criminal investigation or against you in in criminal court if that's where it ends up. So very important. Please keep those investigations totally separate, and don't let anybody talk you into doing anything else otherwise, or trying to combine them, putting them together. All right, so just like when you were trying to pick your administrative lawyer, you want to make sure that you have the right criminal defense lawyer. The difference here is your union will generally provide you with a lawyer, and that lawyer is going to be versed in employment matters, and they're going to be versed in all of your constitutional rights associated with union membership and associated with public sector employment. Criminal defense attorney is generally a lawyer that you're going to have to go out and get on your own. There are some resources out there that can help you select the right one. If you're members of Nutmeg, all you have to do is call us, and we will refer you to a lawyer that we know and that we trust is going to do the job and do the job properly for you. But you want to make sure that they're experienced in handling felony cases. You don't want that first year law student or someone who's an associate in a small criminal defense firm who's only been handling DUIs and some traffic tickets. You want somebody that knows the courtroom, knows how to litigate, knows how to investigate, and has the resources to bring in private investigators and expert witnesses and that kind of stuff. So you want someone that's seasoned, and you want someone that's experienced. So like we said, I mean, they're very similar to your traditional homicide case or any other major felony case as far as the way they are moved through the court system and the way that they're prosecuted. So if a defense attorney is well experienced and well versed in handling homicide cases, they're going to understand all the evidence, they're going to understand all the medical examiner reports, and they're going to be able to navigate the court system and work with the prosecutors and to give you the best chance. They also have to be familiar with police practices. And as strange as it sounds, not all criminal defense attorneys are truly versed in how police departments operate, how police officers are trained, and how they go about doing their everyday job. But if they don't know that, at least have a basic understanding of that, they're going to have a hard time developing a defense to help defend against the prosecution. And they also need to be able to bring in expert witnesses, and those expert witnesses need to truly be experts. So, and you can't have one expert witness that knows everything about police work, because nobody does. None of us know everything about police work. And we'd be crazy to think that we do. So as an example, if it's a shooting case, you're going to want to bring in somebody who's an expert on firearms training and the policies and the laws of use of force. But you're also going to want to bring in somebody that's an expert in crime scene. You're going to want to, be able to explain some of the evidence, and you're going to want to have somebody come in, another expert witness that can talk about psychology and how the officers are primed during dispatch and listening to the radio, and how that might affect their decision making once they respond to the scene. And these are just a few examples. There's probably hundreds of different experts out there that all have different areas of expertise, and a good defense attorney is going to be able to find them and use them to help them put their case together so that you have the best defense possible. And again, this is expensive, but if you're in one of these legal defense funds, a lot of this is covered. So it won't come out of your pocket, and it won't cost you your house or anything like that. And also make sure that they're familiar with the court that it's going to be in. Don't hire a state criminal defense lawyer who's only practiced in state court if the case is going to federal court. You want somebody that knows the federal system and knows all the rules and the ins and outs of a federal criminal trial, because it is a little bit different than state court. All right, couple of very, very bold points that I want to make, and I want to make sure that everybody understands. Again, I've said this a few times, and I want it to be kind of one of the big takeaways tonight. Don't ever allow the administrative and the criminal investigation to be combined in any manner. Don't put everybody in the same room and do one interview. Don't have the same agency do the investigations where they can easily talk to each other and communicate and share information. And just keep them as separate as possible. Your rights under the administrative investigation are far different than your rights under the criminal investigation. And like we said, they often conflict. And a good example of a conflicting right is your right to remain silent. In the administrative investigation under Garrity, they can compel you to speak. They can give you, your chief can give you an order to answer the questions and answer the questions truthfully. And if you refuse and say, I'm invoking my Fifth Amendment right to remain silent, you can be disciplined up to termination just for refusing to talk. So that's an important distinction to make in an administrative investigation versus a criminal. In a criminal investigation and in the criminal interview, you can say, I'm invoking my Fifth Amendment right to stay silent. And you don't have to speak to the criminal investigators, but you do have to speak to the administrative investigators. So that's just one example on two conflicting rights that, and if you allowed them together, really could jeopardize a criminal case if it were to ever come to that. And obviously we hope that it never does, but we want to make sure that you understand the differences and make sure that you're doing the best for yourself, and you're making sure that you're making the right decisions and making sure that your lawyers can work together and put up the best defenses on both fronts for you. So the next thing we want to talk about a little bit is writing your report and writing your IA memo. And one of the biggest questions that comes out before you write your report, it's kind of why I put the slide here, is do you watch your body cam footage? And there are a couple of different schools of thought on that. And there are some lawyers and some police trainers that will tell you absolutely never watch your body cam video before you document the events. And the reason they say that is the legal standard that you're going to be judged against is not necessarily based on what actually happened. It's based on your perception of what happened at the time you pulled the trigger or at the time you used whatever force you used. And by not watching the body cam footage and typing your report, you're going off memory. And nothing's tainted, nothing's been changed. You're writing truly what you felt and what you perceived at the time of the incident. Option number two, some people will tell you you have to watch the body camera footage before you write your report because you have to make sure you get all the details right and put everything in the right order, make sure you got all the radio transmissions right and what commands were given and all of that. And there is some importance to that. And I think both of them definitely have pros and cons. I'm going to give you my 2 cents in a second, but before you write your report, talk to your legal counsel first. Talk to your administrative lawyer, talk to your union lawyer, and talk to a criminal defense lawyer if it's even come to that. You may not have one. You may have, your union may be able to help you with that, but talk to your lawyers and decide what approach to take before watching the video, please, and before writing your report. Now, my 2 cents is I like to take a combination approach. What I think you should be doing is I 100% agree that you should not watch your body cam footage before you write your report, or at least the first half of your report. And so what I would like you to do is not watch the video, sit down and start typing. Type almost like a brainstorm. Type out all of the details that you can remember, all of your feelings, all of anything you can remember about the scene, anything and again, it goes back to your perception. So you want to talk about the radio transmissions, how that made you feel, how you responded to the scene, whether you went lights and sirens. Again, this all goes to stress, and you want to write down as many details as you possibly can. And once you get that part out, then I think it's good to go back and watch the body cam footage, go through all of the minor details and document the details. And the last part of your report should be sort of an explanation on why sometimes some facts may not line up with your perception. And I think it's important to document that up front and document it in painstaking detail. And we're going to talk a little bit about that in a minute too. Because if this were to go to trial, whether it be a civil trial or a criminal trial, 2 or 3 years down the line, you may not remember those details, and so the footage might be lost, or you may not be able to explain your perception. You may have forgotten about it, and so try to get as much on paper early on. And we're going to talk a little bit about why. Just like we talked about in the last webinar, don't write a report, don't submit to an interview, don't do anything for at least 24 to 48 hours. Your brain needs that time to de-stress. You need to flush all the stress hormones out, and you need to have a couple of good solid sleep cycles. And you'll actually remember more details and be able to remember the incident with more clarity. And that's important. And you won't, might help take a little bit of the emotion out of it as well. Again, know the laws and your policies, and read them. Before you write your report, go back through your use of force policy, go back through your officer involved shooting policy, go back through your domestic violence policy if it were a domestic case, or whatever policy is, whatever policies are pertinent to that section, to this incident. Read those policies, get an idea of what you need to, what you sort of need to account for, and read the laws, read your use of force statutes, read other statutes that again might be relevant to your situation. If you have to, sit down and make a checklist. Make a checklist of all the different things that you need to document, or at least account for, and why you can't, and explain why you can't document. Like, so as an example, in the new police accountability bill here in Connecticut, one of the ways the prosecutors can Monday morning quarterback an officer involved shooting is by having the officer explain what was in the background. And the law says you have to acknowledge what's in the background and take that into account before you pull the trigger. Now, we all know that that's probably impossible to do, but they're going to be able to maybe call you out on that a little bit and use it as a place to start an investigation. So you're going to have, you want to at least account for that and discuss why it was dark. You couldn't see what was back there. I mean, your vision's going to go, all the way down to nothing. So it's going to be really difficult to do that. And that's where experts are going to come in and help explain this. But you want to try to work through some of this stuff in your reports as best you can. And anything you write, any notes, any reports, any memos, anything, make a photocopy, put them in a file, and take them home with you. Keep them, keep a copy of them. And just this way you've got them. You can refresh yourself down the line if you have to go to a hearing or a deposition or something like that. And you don't have to worry about them getting lost or misplaced or changed in any way or something like that. So keep a copy. It's going to benefit you in the long run. And one thing that everybody used to always say in these reports is something along the lines of, I had to shoot because I felt my life was in danger. And then they leave it at that. And the old school way of doing that was always a less is more mentality. I mean, even when I went to the academy in 2000, you were basically taught, don't write super detailed reports when it comes to use of force. They want room for interpretation. And if you have to explain things later down the line, you can. Unfortunately, times have changed, and there really is you may not ever get an opportunity to explain this further down the line. You hope you never have to do this on the stand. And if you do have to do it on the stand, it's going to be, a year or two later, and it's not going to be just you explaining your side of the story. It's going to be a prosecutor cross-examining you, or your own attorney trying to directly examine you and get some of that information out. So it's not going to flow as well as a well-written report. So you have to document the why. Why did you feel your life was in danger? And you have to do this in such painstaking detail that what you might be able to do in a paragraph is going to take 5 pages. And that's how important it is. You really want to make sure that you explain this, every little detail. You want to make sure that you type out. And one of my examples here, if anybody is an airplane fan, Captain Rex Kramer talking the pilot down. So think of it as that, an air traffic controller or somebody on the ground trying to talk a pilot down, or a person who's behind the wheel of an airplane who has no idea how to fly, and you have to walk them through a landing. Every little detail is important. Every little detail is, even a minute detail could cause that whole thing to come crashing down. So painstaking detail, every little detail matters, and really explain the why. And that's the second point that I want you all to take away from tonight, is document the why. You cannot just say, I thought my life was in danger, or I thought this person's life was in danger. You really have to explain why. Just some other simple report writing tips. At the beginning of your report, write it in chronological order. We all know how to write a report. I don't have to teach you that, but when you write it in chronological order, it makes it easier for people to understand. And again, going back to the details, write what the dispatcher told you. There's one of the psychological phenomena that are being studied more and more now today is that of priming. And when you get a call and the dispatcher is screaming over the radio telling you that there's shots fired, your adrenaline's going to go up, your stress levels are going to go up, and that affects your decision making. We're trying to train dispatchers to be a little bit more even keeled, but when you have a hot call, you never know. You don't know how the dispatcher is going to react. So, but document that, because if there was a situation where you were primed early on, and maybe the call didn't turn out to be such a serious call, but you're going in there already amped up with the adrenaline, with an adrenaline rush, you may be more apt to use force. And that needs to be explained. And we can explain that through the use of experts, but part of that is documenting that in your report, what the dispatcher said, what their tone of voice was, how urgent did the call sound. So keep that in mind. Again, detailed pictures, make it as vivid as you possibly can. really paint a picture and try to get whoever's reading it to feel like they were there in that same situation. Again, wait 24 to 48 hours. You want to make sure that that's important. Don't write anything. Don't submit to any interviews until your brain has had a chance to recover. Use spell check and grammar. You want to make sure that your reports are not only easy to read and full of detail, but you want them to look professional as well. Especially with an incident like this, there's going to be a lot of people reading these reports, including news media, social media users, other prominent people in the community, the politicians, and make them sound as professional as possible. Use spell check, use grammar check, have somebody proofread it for you if you can. And what I like to do, what helps me catch my typos, because I read over them all the time. When you finish writing, put it down, come back to it the next day, following day, 24 hours later, whatever works for you, and then proofread it. Sometimes it might help you pick up some of those errors that you might have missed the day before. So it just helps to make the report look and sound more professional. So after you're done with the writing your report, you're going to want to prepare for the interview. Again, and I keep harping on this, 24 to 48 hours. Don't do anything before that. Your brain really needs that time to recover. Meet with your legal counsel before. Talk about how the interviews are going to go in both the administrative and the criminal. Know your reports and your memos and everything that you've written, whether it's supplement reports, know them cold, know them in and out. So if someone were to ask you questions about them, you could answer those questions without having to refer back to the report. And what I like to do is sit down with the officer involved and write a statement, essentially. It's essentially going to be your report or your memo in just a slightly different form. The substance, though, is going to be exactly the same. But what I like to bring a copy of it, a printed copy of it, and an electronic copy of it. So when you walk into the interview, you sit down, you just hand it to the investigator and let the investigator read it over. And if they have any follow-up questions or any other details that they want to fill in, we can work through those questions. But there really shouldn't be too many questions because your report and your memo is going to be so detailed. And you want to be able to give that over, and that's going to be your statement. And hopefully there won't be many more questions, because it's easy to go down rabbit holes when you're sitting there answering questions. It's much easier to hand a copy of the report over or a pre-written statement, and that be the statement that's generated at the end of the report. And like I said, I like to have a written copy so that they have something to look at, and an electronic copy in case it has to be copied and pasted into a specific form, or the state police have particular statement forms that they like to use. So it's just a lot easier for everybody. And the interviews generally last half an hour, and most of it is time spent reading and maybe asking one or two follow-up questions. So to me, I think that works very well. You may get some investigators that want to sit there and ask questions because they think that that's what they have to do. And that's fine, but that's why you need to know your reports and your memos cold, because it all has to match. Your reports, your memos, and any questions that you answer during an interview all have to match up, and everything has to be the same. So know them inside and out. I think that's really, really important, and make sure that you prepare before any interviews with your attorneys. All right. Again, when you're sitting in there, make sure that your attorneys are versed in the type of law that they're going to be using, whether it's administrative law or criminal law. Make sure they're protecting all of your constitutional rights, and listen to your attorney. If in the middle of a question, your attorney asks a follow-up question or tries to clarify something, don't talk over them. They're doing that for a reason. Just get in the habit of when the attorney talks, you shut your mouth and stop talking. Let the attorney ask their questions. There's a reason for them, whether they're trying to clarify something, whether the question is improper, or whether the question is misleading or something like that. The attorneys are there to protect you, so let them protect you. If they speak up during an interview, just stop talking. Even if it's in the middle of a word, in the middle of a sentence, just close your mouth and stop talking. And afterwards, meet with your attorney, debrief, and talk about what went well, what didn't go well, and if there is any concerns that the attorney might have going forward. So that's always a good thing to do. All right, so we have about 10 minutes left, and which is kind of right where I want to be. I do want to talk a little bit about stress and your mental health, but like I said, in part 3, we're really going to focus on this. So we're just going to touch on this quickly and just go over some of this stuff. But as you know, being involved in an officer-involved shooting or a serious use of force incident is one of the most stressful things that you're ever going to go through in your life. And that puts a lot of stress on you. And when it puts stress on you, it really can cause some pretty significant mental health issues. And don't take that the wrong way. That's not a bad thing. You just have to recognize the signs and symptoms and get treatment. Because if you don't, it can damage your home life, it can damage your work life, it can damage your social life, and it can lead to more severe mental illness that could eventually lead to things like suicide. And that's the last thing we want. We want to prevent, obviously, all officer suicides, and being involved in one of these situations, if you don't get your mental health treated and take care of your mental health after an incident like this, it could lead to more damaging effects. One of the big things that we talk about with any of these stressful incidents is PTSI. Now, PTSD is generally the term that you hear, but it's not so much a disorder, it's really more of an injury. So kind of the new way of explaining it is post-traumatic stress injury. And it is an injury to the brain, just like any other injury that you might sustain, and needs to be treated medically. And there's no stigma to it. There's nothing wrong with reaching out to a mental health professional, reaching out to EAP, talking to colleagues, whether it's through a formal peer support program or just informal conversations. But one of the important things you also need to do is treat with a professional. You are going to want to talk to somebody, and you want to keep an eye on some of the signs and symptoms of PTSI. And some of those symptoms really, they might be very mild, or they might be severe, and they may prevent you from sleeping, or they might prevent you from going about your everyday life. And the more severe the symptoms and the more they affect your everyday life, obviously the quicker you should be reaching out for professional help. And again, there is no stigma to that. And it's very important if you want to return to your career, and even make sure that you stay physically healthy. Your mental health and your physical health often play hand in hand. So some of the symptoms that you're gonna want to be concerned about are reliving, something like reliving the events, nightmares, flashbacks. You purposely trying to avoid thinking about it, or if you're drive by the Dunkin' Donuts where the incident happened, and all of a sudden you're reminded of that, and you start having flashbacks. A lot of times people have self-guilt. They believe that they could have done something different, and that really can weigh on them, and they can start feeling have negative feelings about themselves and start feeling bad about themselves. Hopelessness, memory problems, which is really, if you, when you start um, sort of blocking out some of the memories of the incident, um, and you can get into some more social issues, like, you know, you can't maintain friendships, you have family problems, marital problems dealing with your children, or just, you know, other people in society in general, or just feeling completely emotionally numb, where you have no sense of emotion at all. These are all rather serious signs, and you really need to get help. It's just another slide with some more. This will all be available on our website, so I'm going to obviously read through all of them. Other things, though, you know, when you start hearing different sounds, getting involved in different situations, when they start making you relive the problem or the incident, then that's a problem. And alcohol, self-medicating will only make these symptoms worse. They're not going to help you. It's not going to help you in the long run. It may, you know, help you sleep through the first couple of nights by not so much sleeping, but more passing out than anything. But that's not going to fix the problem. In fact, there's a lot of studies out there that say that it actually makes the problem worse, and it makes these symptoms a lot worse. It makes your dreams worse, your memories more vivid. So avoid alcohol and avoid self-medicating. We talked a little bit about this already, but how to get help. Use your EAP. EAP is a great resource. If there's a regional peer support team or a local peer support team, talk to them. They're trained. It's confidential, and you know, at the very least, they're going to be able to point you in the right direction for more professional help, like a psychiatrist or a psychologist. And they're going to be able to prescribe you medication. They're going to be able to use other therapy, like the eye movement desensitization and reprocessing treatments, medications. If it does lead to substance abuse, they've got resources for substance abuse treatment. And all of this is going to not only help your mental health, but it's also going to help with your physical health. Here's a few numbers. If you're feeling suicidal, or if you have a substance abuse problem, if you really are having a hard time and struggling with some mental illness, there are some resources here if you don't want to talk to somebody within your department, or you're not comfortable reaching out to your EAP. And again, here at Nutmeg, we have all these resources available, and we have other resources available that we can use. So if something here, if you're not comfortable with something, we have some other, you know, sometimes out of the box thoughts that we can work with you on and get you the help that you need. Again, it is really, really important to take care of your mental health after you're involved in an officer-involved shooting, an in-custody death, or a serious use of force incident. Again, try to live a healthy lifestyle. You know, that's really the good thing. That's really the big thing. Get some good sleep, exercise, join a gym, try to get back into your own routine as quickly as you possibly can. Don't isolate yourself, and don't self-medicate. That's really one of the most important things. As much as you're going to want to go out and drink and you know, try to forget it all, that's really the worst thing that you can do for yourself. And when it comes time to getting back to work, you really one thing that you want to make sure is that you are ready. Make sure that you are not having any of those other PTSI symptoms that we talked about. You don't want to be already irritable when you go back in. You want to make sure that you can actually sleep at night. You don't want to be feeling stressed. You don't want to be having flashbacks or reliving the incident. Make sure your physical health is good and your blood pressure is not too high. And you know, be careful with drinking and sometimes using other drugs. I use the word drugs here, not so much in an illicit sense, but you know, even prescription drugs. You know, there may be some prescriptions that you need to handle some of the signs, some of the symptoms of PTSD, PTSI, but you don't want to be reliant on those drugs. And if you were physically injured in the incident as well, you want to make sure that you're off the pain medications and stuff like that before you come back to work. And really the biggest thing and the biggest gauge as to whether you can come back to work or not is really on you. It's whether you feel that you're ready. And if you get back to work and it's just all of it just starts coming back to you, and you think in the end you're really not ready, then don't be afraid to talk to your supervisors and go back on administrative leave. And to be honest with you, some people never recover from something like this and are never able to come back and be a police officer again. And, as unfortunate as that is, sometimes it's better for everybody in the long run. And, talk to your union about it. If you're a Nutmeg member, we can help counsel you through this. And if you have to transition out of the police career, we have resources to help you do that. So again, healthy lifestyle. That's really one of the most important things. Before you come back, your policies and procedures, your department, they may want you to get a fit for duty exam from a doctor, from a psychiatrist or a psychologist. It's just a process. Don't get upset about it. It oftentimes is an important protection for the employer. So talk to your union about it, make sure that it's accounted for in policies and procedures in your contract. But for the most part, it's probably a necessary step. So just do it. If you really want to get back to work, go through the process and get back as long as you're ready. And with that, I think we're just about finished. I purposely didn't spend too much time on the mental health aspect of this. We are going to be doing a part 3, and that is going to focus almost exclusively on the mental health aspect of being involved in a stressful incident like this, and how to go about getting help, getting treatment, and how to know and how to get back to work and get back to your regular life with as little negative effects as possible. And again, it's really important to get some treatment after this, some counseling, EAP. There is no stigma to it, and don't let anybody tell you that there is. There is, it's much more beneficial to you to get some treatment than not. There really could be some long-term effects that you can avoid with just a little bit of help. Here's my contact information. Again, Jay Pugliese, Nutmeg Independent Public Safety Employees Union, Law Office of Eric R. Brown. If you have any questions, if anything has come up in here, this webinar and the PowerPoint will be available on our website, nutmeglaborunions.com. And if you have any questions, my email address is here. Don't hesitate to email me. The phone number's up there. If you have an incident, and even if you're not a member and you want to consult, by all means, we're here and we're willing and we're ready to help. So we can only practice in Connecticut, but that certainly doesn't mean that we can't consult with your union or your administrative lawyers. So if there's anything we can ever do for you, by all means, don't hesitate to reach out. And with that, happy Tuesday, the 2/22/22, and have a good night. Stay safe out there.